When life gets unpredictable, preparation matters. In medicine, it's all about staying alert, ready for whatever comes through the door. On the road, it's no different. That's why Volvo designs vehicles to help anticipate risk, reduce harm, and protect lives. The Volvo XC90's advanced safety systems inspire confident decisions wherever the road takes you. The Volvo XC90, for life. Proud sponsor of the Pit Podcast. Learn more at volvocars.ca/safety.
Time for us to say good afternoon to Chris Dimakos. He is our CJAD legal contributor. And Chris, interesting story we're going to touch on, but the implications, I guess, can be pretty wide and worth noting as well. We had numbers this week showing job losses in Canada. And by the way, Quebec, worst hit of any province. Not good news on the employment front. So let's talk about this particular situation. This happens to be about a Starbucks manager who'd been working for the company for about 8 years. Had to go on paid leave for mental health, comes back to work after about 3 months, and what happens?
So he comes back to work, and he basically has a casual conversation with a coworker saying, I can't do my basic tasks. I'm not able to do these things. I don't even know if I can do my job well anymore. And somehow, some way, that gets back to his superiors. They meet with him. They're telling him to take some more time off. He's reluctant to do so. Finally, they approve another time away to try and get better. He does take that leave. He doesn't seem to work. Finally, there's a conversation between Starbucks and this employee where they present a letter to him on the spot, no advance warning, saying, "Look, we're willing to give you this as a parting package. Here are all the details. If you think about it, let us know." So he then sends a casual email just saying, "You know what? I looked at it. I think I'm good with it." And that's it. It wasn't in detail. Just a quick email. Finally, they send over the formal agreement. He refuses to sign it. They tell him, "That's it. If you don't sign it, well, then that's your problem." He goes to court, files a wrongful dismissal, and when it got to court, the question was that email that he sent, was that enough to replace the formal agreement? Just by saying, "I'm good with that," is it enough for Starbucks to say, "You agreed to it, sorry, you can't ask for anything more"? And the court said, yes, it was enough, even though it wasn't a formal agreement, even though he didn't sign it. The fact that all the terms were there in that letter, and the fact that he sent that one-line email, that was enough to stop him from being able to file a formal lawsuit. So, the moral story here is, we're right now, you just mentioned it, we're in a time unprecedented. The last time we saw these types of job number losses in Canada, I think, was with the meltdown in 2008. So it's been decades since we've seen this. Many people are in that phase where companies are starting to reevaluate different positions and cut workforce to try and save and weather the storm here in Canada. So it's not always textbook. It's not always they bring you into a room, they present you with papers, they give you a week, you'll review with a lawyer. Sometimes there's a lot of gray. And in this case, this employee, acted too quickly, and it barred him from being able to, request the full amount of which he thought he was entitled to.
So, okay, I'm trying to understand this. The initial email, the informal one that he said he was okay with, was it a matter of showing that the formal one he got was that much different from the first one? Like, what would be the difference here?
Yes, so great point. It wasn't, and the judge used those exact words. The formal agreement didn't differ from the letter that they had showed him. So when he agreed to it, it wasn't like they presented him with something different afterwards. And because they were so similar, and you hit the nail right on the head, that's where the judge says, well, you accepted it. Even though it was just a quick email, you shouldn't have been so nonchalant about it. You should have taken time, gone to see a lawyer, gotten the advice, and then come back with what you thought was sufficient.
It kind of sounds to me like, the decision made, and again, I'm just kind of, I'm hypothesizing here. He gets this first notice, and maybe this is the best way to go. You don't have the ability to change your mind after having said yes, regardless of whether the formal letter was very much different from the original one. But is that really the case here? I mean, if you've told your employer, you've worked out a deal, you're leaving, and it's been all agreed, do you not have leeway to change your mind at any point before you sign off on a formal agreement?
Yes, there are times, and the times are there where you show that when you agreed to it, there was signs of duress, you weren't advised, you didn't have an opportunity to meet with counsel. All of these different types of recourses you may have to back out of something you might have agreed to, not being fully aware of what you were saying yes to. That being said, for many people, you might be thinking about this and how it applies to you. What's so important if you are an employee right now, during this time, I would tell you, I often talk about the chess war of information. Anytime you sit down in business or in contracts or employees, there's always an exchange of information, and you want to be on the winning side of that. You want to provide less information, and you want to obtain more information from the opposing party you're sitting next to. So if you ever are in a situation where your employer, a manager, a coworker comes and talks to you about your employment, about your future, about a package, about the possibility, the best thing I tell everyone is, what you want to do is not divulge information. You want to say, okay, let me digest what you just said. I'll get back to you. And you want to leave that situation, whether you're in a boardroom, whether you're having a coffee at lunch, whether you're playing racquetball with a coworker after work. You want to leave that situation divulging as little information as possible about what you intend to do, what you think is sufficient, what your future plans are for work. All that stuff can have an impact on your severance. You don't want to be giving that out until you had time to contemplate, hey, is this a good deal? How should I play this? What are my rights? All these things you need time to assess. So I always tell somebody, make sure you don't lose that chess war of information. Make sure you leave having more information than they got from you. And if you do that, usually you end up winning in the end.
Yeah, so this is the let cooler heads prevail theory, which I guess makes sense. But I wonder, too, in some cases like this, your employer is going to present this to you and then give you a time limit, right, before you have to get back to him or her.
Absolutely. They do give you a time limit, and it's a time limit that they're very well aware can have consequences. If it's too short, it can backfire on them because the courts will say that you didn't give them enough time. So they usually give you more than a few days to be able to consult. But all of these release agreements, they all include a clause. I mean, if they're smart, that you have had the chance to consult with legal counsel, you had the time to evaluate this, and by signing this, you're doing so being well advised. So make sure if you're in that situation, you don't act too quickly. You're not. This is not a case where you want to say, it's going to be done with this and move on. You're talking about your equity that you've gained over the years while you've worked at a job. So you don't want to concede that too quickly.
Which would make sense at that point, at least to consult with a professional, talk to a lawyer for that one time you have to do it, just to know what your rights are. And, as you said, it could make a significant difference in terms of what you end up with as severance. I mean, that seems to kind of make sense.
Absolutely. And you want to play out, one of the key conversations I usually have is, here are your options. If you accept, this is what happens. If you don't accept, well, this is what happens.
Right.
Here are your options. And you talk about how long, what the cost is, what's the likelihood, what are the risks. And you just play out all the different scenarios before you make an educated decision on what's the best course moving forward. And, your job, who you are, who you work for, all of these variables, you have to evaluate all of them, because if you don't, sometimes you end up making a wrong move. And like I said, in this case, it cost this individual, I would say at least $20,000 in severance. So it's not a cheap, uncostly mistake, to say the least.
So just to wrap up to your point, which I love you describing the chess words, you know what? You're presented with termination. Simply take it and say, I'll get back to you. You don't have to say anything else.
Exactly. Yeah. It doesn't have to be an actual termination. It can be a performance review. It can be someone saying, you're not doing so well. We're going to be monitoring this aspect of your job. Anytime you're in that mode, I call it termination mode, where there's a possibility that your job is on the line. That's where you want to stop the flow of information from you to them and increase it from them to you. The more you have from them, the better off you are.
Always great advice. Thank you, Chris. Appreciate it.
Thanks, Aaron.
The newest tracks. Let's go. New music. And the next big thing.
Always on the new music first.
Your first place to hear it all.
'Cause you gon' like it, love it, wanna play it twice. Playing now.
iHeart New Music. Your digital station for brand new drops, fresh finds, and tomorrow's bangers.
I think we need something new.
Discover iHeart new music. Always fresh, always first. Stream now on the free iHeartRadio app.